Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Good afternoon. Thank you everybody for joining us today for our webinar program, Pathways to the Settlement of a Catastrophic Injury Case. My name is Katie Jones with ADR Services, Inc., and it is my pleasure to present our program this afternoon. So without any further ado, it is my great pleasure to introduce today's moderator, Judge Victor Persone. Judge Persone is recognized as a Daily Journal top neutral, and he's now a full-time mediator, arbitrator, and discovery referee with ADR Services, Inc. since 2007. Judge Persone brings 45 years of legal experience to his practice, including 23 years of judicial experience. Known on the bench for his courteous demeanor, his thorough preparation, and his excellent knowledge of the law, he's earned a reputation as an effective and serious ADR professional whose grasp of complex issues brings high stakes and often high value disputes to resolution. So he is perfectly situated to assist us with this program on catastrophic injury and all of the challenges there too. Judge Persone, I will turn it over to you to introduce your next speaker.
Thank you very much, Katie, for the introduction. I appreciate that. Ladies and gentlemen, good afternoon to you. I'm going to, first of all, introduce the speakers that you're going to hear from this afternoon, as well as give you an overview of what you're going to be hearing from the individual speakers as we move forward. Our first speaker will be Barbara Greenfield, who will be discussing developing a life care plan. Barbara is a certified case manager, a certified nurse life care planner. She provides life care plans for plaintiff and defense. She specializes in life care plans for victims of neurotrauma, multiple trauma, chronic pain, and chronic disease management. Our second speaker will be Karen Smith, who will be determining and helping you learn how to determine present cash value. She is a forensic economist specializing in personal injury, wrongful death, medical malpractice, and employment cases. She has over 32 years of experience and works on behalf of both plaintiffs and defendants. After Karen, we'll be hearing from Mr. Stan Schultz about his role as a settlement consultant. Stan is one of the founding principals of IBAR Special Needs Trust Advisors, formerly IBAR Settlement Company, founded in 1984. He currently serves as president and chief executive officer of IBAR and has worked as a settlement consultant on over 2,000 cases, 800 of which are special needs or settlement trusts. Following Stan, we'll hear from attorney Randolph Sharon, who will discuss the different trust and trustee options for attorneys and their clients to explore. Mr. Sharon has been an attorney for more than 39 years. His practice consists of a broad range of trusts, wills, estate planning, and probate-related matters. The primary emphasis of his practice is the establishment and administration of in excess of 500 special needs trusts and court-established settlement trusts. The purpose of today's discussion is to establish a clear path to secure long-term financial vehicles and capable custodians that will address the specific needs of a plaintiff with permanent catastrophic injuries. Attorneys must be familiar with all aspects of the settlement process. Today, we'll discuss how attorneys can best navigate the settlement process, who the other key players are, and when each of these key players should be brought in. Whenever possible, involve the clients early in the settlement process. This can help avoid a situation where your client feels rushed into making a major financial decision for themselves or their loved one. Going through all the potential settlement options early in the process will leave them feeling that they are involved and confident when it's time to make a final decision. It is also important to advise your client that in cases of minor or incompetent adults, the court must approve a settlement and will have continuing oversight for the remainder of their lifetime. Once cases are approved in civil court, they are transferred to probate court for ongoing oversight. In California, the probate court will require a full accounting at the end of the first year. After the first year, the court will require biannual accountings. These accountings are often complex and may require the involvement of CPAs and probate attorneys knowledgeable in the safety requirements of the court, in addition to state and federal filing requirements. For families already dealing with care needs of their loved ones, all this can be overwhelming. The goal. The purpose of this seminar is to help both plaintiff and defense counsel reach an agreed upon solution to resolve the settlement of a personal injury matter involving catastrophically, permanently injured individuals. There are several stages common to most successful settlements, which we will describe in this presentation in greater detail. Bringing in a mediator. Typically, a mediator is brought in during a personal injury dispute if both sides are willing to negotiate but are not close to reaching a resolution themselves. A mediator can be brought in at various stages in the litigation process, and this is one of the considerations that you as the attorneys will have to, as well as the mediators, will have to understand. It can be brought in at the very start of the process in hopes of receiving an amicable solution before a lawsuit has ever been filed. When initial negotiations between two parties have reached an impasse, but before a lawsuit has been filed. After the lawsuit has been filed, but negotiations are still ongoing and both sides are still far from a resolution. Or when litigation is close to trial, but both sides, often ordered by a judge, still seek to resolve the matter out of court. Once brought in, the mediator will need to rely on the input from the various experts in addition to legal counsel from both sides to come to their determination. Nearly every personal injury litigation will at some point require the input of various experts and advisors to accomplish a successful resolution for the long-term care and life needs of the plaintiff. As mentioned, our speakers today will include a life care planner, forensic economist, settlement consultant, and attorney specializing in probate and estate planning. Each key player will be called upon to answer critical questions as both sides work toward a resolution. For the life care planner, what are the plaintiff's injuries? What level of care, therapy, accommodations are required to meet the needs of the plaintiff? For the economist, based on the life care planner's diagnosis, what is the present value or cost of the various services, medical supplies, lodging, etc., needed over the plaintiff's lifetime? For the settlement consultant, what are the court-approved options available for placing funds once a settlement is reached? For the probate attorney specialist, which of the options is best, considering the circumstances and needs of the plaintiff, and then who should be involved moving forward? I'd now like to introduce our first speaker, Barbara Greenfield, who is our life care planner.
I'm sorry, Barbara, please unmute yourself.
Okay, let's try that again. So, hi, everyone. So, as Judge Persone noted, I am a life care planner and I'm here to present regarding life care planning. A life care plan is an individualized long-term treatment plan. As a clinical nurse, I develop treatment plans for all my clients or patients. When someone wants to know what I do as a life care planner, I state that I develop a document for attorneys that calculates and illustrates long-term medical damages. Other professionals, such as occupational therapists, social workers, and physicians, can develop life care plans. They can be certified life care planners as well. They must follow their own professional guidelines when developing a life care plan. The defense may utilize the plaintiff's life care plan if usually it's if the plaintiff's life care plan is less costly. That's rare. However, as the slide states, the plaintiff and the defense will hire their own experts. The methodology for a life care plan is somewhat dependent on the professional writing the plan. As a nurse, I utilize the nursing process. We will discuss that in a later slide. All life care planners will review records and perform an independent interview and evaluation of the client. As a nurse, I perform client evaluations to assess clients' functional needs, such as can the individual perform their activities of daily living, or do they need assistance from a device or a person? Can they perform higher level activities such as driving, taking care of their finances, grocery shopping, cooking, caring for their children or parents if that was an issue? Can they work? The evaluation also determines the client's physical needs and assess their range of motion, their strength, their gait. Use of equipment is really important. They also need to know about the injured person's cognitive abilities. Then we create the life care plan or start that process to remediate the deficits. A critical part of the life care plan is the cost of care. Many of my colleagues and I utilize databases and other established documented resources to obtain costs. Before 2019, costs were assessed mainly by calling providers and facilities. However, in 2019, the Sanchez ruling, which addressed general versus specific hearsay, made it important for us to find other resources for that process. It's important to establish the foundation of the life care planner's expertise based on their professional education, experience, and knowledge. So review their CV. My other colleagues will discuss the settlement process in more detail. The life care plan is produced during litigation, during the litigation process to determine the plaintiff's needs and the cost of medical treatment. The plan then goes to the economist and Ms. Smith will review her process. The life care planner initiates the process and is the driver of collaboration with other experts, including physicians, orthotists, prosthetists, educational advocates, and vocational experts. It's often challenging to coordinate the schedules of the experts. Coordinating these discussions is often tricky, and I often require the assistance of the attorney. The life care planner then completes this process. For instance, I request that my deposition be scheduled next to last, with the economist being deposed last. That way, if and when one of the other experts updates or changes their opinions, this can be reflected in the life care plan. During the process of collaborating with physician experts, the life care planner should document the discussions, as this can also be an issue of hearsay. The other experts should review and sign the document. So the life care plan must be easy to decipher. The report is sent to the attorney and reviewed by the economist so they can develop their report. During the economist's review of the life care plan, they will often call me to review any questions they may have regarding numbers, frequency and duration of treatment. The economist assesses for present value. If asked, I will provide total cost of care. However, I don't assess for present value. Some of my colleagues do. Once all the I's are dotted and the T's are crossed, the final product is provided. So the life care plan is utilized by a number of individuals involved in the litigation and settlement process. I'm also a certified case manager, and at times I'm hired post-litigation by a fiduciary or a special needs trust to provide case management. And having a life care plan can be immensely helpful. As I stated, it is a treatment plan. So as a nurse, I follow the nursing process. This includes, as the slide states, assessment, diagnoses, implementation, and reevaluation. However, other professionals will follow their guidelines based on their education. Life care planning is a dynamic process. It should be updated based on the client's needs and the physician expert's recommendations. I may be retained as a life care planner in 2024. That's getting short, but for an individual who was injured in 2021, and then the trial may not occur until the end of 2025. I will likely need to reassess the plaintiff more than one time. I also will need to speak with the physician experts more often. During the interim, the patient's age, their situation may change. They may develop new skills or not. They may have procedures such as surgery, or they may suffer other injuries because of their initial injury. So I had a client who was injured in a car accident and incurred a spinal injury. They were still able to ambulate, but needed assistive equipment. They fell and suffered a shoulder injury. So their abilities changed, and so did the life care plan. So as a nurse, although I review and understand medical diagnoses, that's really important, I also provide nursing diagnoses, and most people don't know what a nursing diagnosis is. The nurse's diagnosis require clinical judgment to determine how to remediate the client's impairments. It's important for the attorney to understand this part of the process. So, nursing diagnosis, there's some examples there. It concentrates on the patient's response to illness or life circumstances, which can be physiological or psychological. By focusing on the client's response to injury, a nurse life care planner will determine what interventions are required to address or alter that response. So, this is the nitty-gritty. Medical treatment includes physician evaluations, lots of things, follow-up exams and rehab needs, and I could go on forever. Hospitalization and emergency room visits. An individual with a chronic injury such as TBI or spinal cord injury, or even a child with cerebral palsy, will likely require emergency room or hospital visits. With the help of the physician experts, the life care planner will determine the likelihood of these visits and the length of stay. Medications, most of my clients are on medications. It needs to be both prescribed and over the counter. So in-home care, this part of the life care plan is typically 80% of the total cost. The care may include skilled nurses, LVN or RN, or caregiver and aides. The caregivers provide assistance with activities of daily living, like showering or other hygiene needs, medication reminders. Caregivers cannot give medicine. They also provide light housekeeping, but other providers like a housekeeper or a handyman, depending on what the client performed before their injury, may be necessary, even a gardener. So equipment and supplies is a big need as well. You can imagine mobility equipment, feeding equipment, bathing equipment, and even security systems. But in addition, home modifications such as roll-in showers, a ceiling lift, and ramps are important part of remediating the deficits of the injury. So leisure and activities, leisure and productive day activities, a lot of people don't think about that. But it's really important for quality of life. So I may recommend a community college that specializes in a TBI program, or a gym membership, or specialized camps for children. And then transportation, adapted vehicles, medical transportation, or even Uber. So only approximately 4 to 5% of cases go to trial, as you well know. Therefore, the majority of cases are settled via mediation or other forms of settlement. The settlement determines the amount of money available after costs for the injured person to be utilized for their future care needs. The trial outcome is determined by the trier of fact. They may or may not follow the life care plan total costs. Therefore, the funds recommended in the life care plan may or may not be what's finally available for the injured party to utilize for their care needs.
Thank you very much, Barbara. Now we're going to hear from Karen Smith, the forensic economist.
Thank you, Judge Person. So This is a list of the things that a forensic economist can help you with, but today we're going to just concentrate on catastrophic injury cases and what the economist can do in those. So the role of the economist, we need to collect all of the information, and the attorney provides us with the initial information. Then we may do some additional outside research, internet research, etc. And then we also rely on government statistics and journal articles. Then we need to calculate the past losses, which is the losses up until a date of valuation, sometimes a trial date, sometimes a settlement conference date, whatever we're instructed to do. And then we also calculate the present cash value of the losses, so the earnings, the household services, the life care plan. We use either economists do it differently, but you either use a growth and a discount rate, or you use a net discount rate, which is the difference between the two. And then we produce a report that you can use to try to settle the case, or we are usually ready to do a deposition if we produce a report and or trial testimony. So the process. So the key players are listed here: voc rehab expert, if there's an issue regarding earning capacity or a reduced work life expectancy before the incident, a life care planner like Miss Greenfield, medical doctor if there's an issue about a reduced life expectancy for the plaintiff. We would need their opinion, report, depo. Sometimes we get, being LA, we get these unusual occupations, maybe a musician, a singer, an actor, an athlete, somebody high earning that has some very special skill, CEO or an entrepreneur. And in those cases, we need the help of an expert in that specific field that can opine on earning capacity, where a regular voc rehab expert can't. You need a specialist in that one field, economist. And then sometimes after reviewing all the information and maybe the plaintiff's depo and maybe the interrogatories, we talk directly to the plaintiff. And this usually has to do with earnings issues and fringe benefit issues. To use a sports analogy, the attorney is the quarterback, and they're the ones that make sure that the economists and all the experts get all the information they need and are able to communicate with each other. Gathering the information. I can't stress this enough. It's really important to give the economist a lot of time to do the report, and that way you will get the best quality product you can. If we're squeezed on time, which happens sometimes, but it's best to get them involved early. If they're squeezed on time, there can be an error, or we may not be able to get everything we need, or some vital piece of information may be missing. It just gives more time to make sure we have everything to do the calculations. Sometimes when we're working with most of the time when we're working with a voc rehab expert, it's good to have them speak with each other so that they can share information and brainstorm about earning capacity and share information, documents one may have and the other may not have. And then, like Ms. Greenfield indicated, once we get the life care plan, there may be some minor clarification issues or mathematical errors that we need to talk with the life care planner about and try to iron out where the mathematical error is. They're usually very minor, but it's has to do with wages or frequency, or sometimes when things are needed and when they start or end. Okay, general information for all cases. This is for catastrophic injury, the complaint, the vital statistics of the plaintiffs and their education level, the posing of economist report filed, depo, but we don't need medical records. Usually we have the voc rehab expert and the life care planner to read those, and except for it has to do with life expectancy, we do need the report or depot of the life care expectancy medical doctor. The trial date and location, so we show up at the right courthouse and the right day. And we can check on the progress of the case, if it's been continued or not. Then mediation dates, discovery dates, when our depot needs to be taken, settlement conference dates, and the depot dates of the other damage experts. Just a side note, for past medical expenses, there's no economic analysis in that. It is what it is. So it's really more cost effective to have the attorney's office, have somebody in their office prepare that on a spreadsheet with the item that was the provider, the cost, and what was paid, and the date. Okay, regarding life care plans, we need eventually the life care plans from both sides. If you're the plaintiff, you don't usually get the defense life care plan until after you've done your work. But if you're on the defense side, you want to look at both life care plans before you issue a report. Same thing with voc rehab experts reports. Life expectancy, same thing. We need to look at those. Regarding life care plans, we need to know, like, the equipment. If the person has the item, if they earn it if they already have it, if they own it, or if they don't own it, when they need to purchase it. And then for all the equipment, we need to know how often it will be replaced, and how long they'll need it, to what age. It's mostly to life expectancy. Then we'll also need the specific timings of everything. But the surgeries tend to be the most difficult part, because sometimes there's a range or nobody knows when they're going to need it. But we really need that nailed down, because we need to do the present value, and the timing is very important. And to have all the costs associated with the surgery in the section with the surgeries, not in separate parts of the life care plan. If you want and you want to spend the extra money, we can do the minimum and the maximum. But usually in California, we just do the average, assuming that the plaintiff will incur the average cost over their lifetime of each item. Other areas, as I mentioned earlier, if it's, well, there's always loss of earnings typically if they can't work anymore. But with an adult, you may have to do a specific occupation and benefits. Collateral source offset analysis, in medical malpractice cases, these are allowed. So we would need from the life care planner the costs that is covered by the collateral source insurance, Medicare or health insurance. And then also for earnings, we need Social Security documents, short-term disability documents, long-term disability documents, any other collateral source offsets. We would need that if we're asked to do that. And then finally, regarding household services, Ms. Greenfield touched on this a little bit, but we can calculate loss of household services based on statistics, or if there's some extraordinary household services that were performed by the plaintiff, like care of a disabled child or care of a parent or something like that. But often there's that cost also in the life care plan, or some of it's captured in there. So we need direction from the attorney about how to handle that, whether just to go with the costs in the life care plan or try to make an adjustment and do the statistical household services based on dollar value of a day is the source that everybody uses. Follow-up questions. Again, is there reduced life expectancy? Again, do you want us to consider collateral sources? Overtime, sometimes with young people, they work a lot of overtime, and we need to find out if that would continue through their life or not. Sometimes we need to look at cohort earnings, which are earnings of people from the company that were hired in the same job around the same time. Anyway, it just needs to be addressed whether that should be continued on for the analysis. Possible promotions and training. You might get this from the plaintiff or their parents. And also, sometimes it's good to take the deposition of the employer because they often have insight into this the area and the employee and what the future held for them if it weren't for the incident. So sometimes that's useful. And then finally, on the planned retirement date of the plaintiff. So we always use the mean work-life expectancy based on education. But sometimes we use a lesser amount, like if the person has a public pension, CalPERS pension or something, they have great pension plans. So often those people retire early and will like a firefighter or policeman, we might take them only out to 50 or 55 or whenever they indicated they planned on retiring. Whereas if somebody's self-employed or if they don't have a good pension plan or they've never saved for retirement, or I've had cases where the plaintiff has children that are, of college age or planning on going to college and graduate school, and they planned on working to support them through that educational pursuit. So it's good to work that out before the plaintiff has their deposition. So we can present the united front about the retirement plans. So finally, last slide, wrapping it up. Again, the defense, if you're on the defense as the economist and also the life care planner and the voc rehab expert, you always want to review the plaintiff's expert's work first before you produce your report. And so you want their file and their depositions. And the economist doesn't want the medical records unless it has to do with life expectancy. After the depositions of the other damage experts, the attorney should let the economist know if there was any changes in the report or if they need to update their report or make any corrections with new information. And then the economist can go ahead and finalize their opinions and finalize their report. And they would be ready to issue the report and possibly do a deposition or trial testimony. Then last but not least, after the first report is issued, time may elapse. It's typically a year, or more. The trials get continued, et cetera, and the economists and also, the voc rehab expert and the life care planner may have to update their reports. Circumstances may change, as Barbara Greenfield just indicated. And so we may have to report for those additional events, usually trial. It's usually updated. Sometimes it's for a depot, but also there's new statistics, the economy changes, new statistics come out, new journal articles come out, things like that. That's about it. Thank you so much.
Thank you. Thank you very much, Karen. And now we're going to hear from Stan Schultz, the settlement consultant.
Thank you, Judge Person, and thank you to all the attendees who are joining us here today. By utilizing the reports of the life care planner and the economist, the settlement consultant gains insight into the complexities of the particular matter at hand. With this information, the settlement consultant is prepared to discuss with the plaintiff or defense attorney and their clients the 5 court-approved settlement options to help to resolve a matter of this type. In the case of the plaintiff attorney and their client, it must be made clear the court will remain involved for the duration of the plaintiff's life. The plaintiff's parents must understand they cannot control the settlement's funds, but must opt for one or more of the court-approved options. And for this reason, it is extremely important that the settlement consultant meet early on with the attorney and the parents. The parents must have a clear understanding of the 5 options, because once the court approves the final settlement, it cannot be changed. Now, here are listed the 5 court-approved options. For purposes of our discussion today, we'll be talking about the 3 most commonly used options. Those are structured settlements, special needs trust, and settlement trust. When deciding between which of these settlement options might be best for your client, there are some key questions you'll want to ask. How safe and secure are the funds? Are the funds being prudently invested? What level of accessibility is there to the funds? Are the administrative fees fair and reasonable? What is the level of transparency and oversight of those funds? What are the communication dynamics? And finally, is the plaintiff eligible for public benefits? The first option we're going to take a look at is a structured settlement. A structured settlement is an agreement between the plaintiff and the defendant wherein the plaintiff agrees to receive a portion of the settlement funds in future periodic payments in accordance with Section 130 of the Internal Revenue Code. Now, under the code, there are only 2 ways to fund a structured settlement: an annuity, which is issued by a life insurance company, or by the purchase of direct obligations of the U.S. Treasury. This would include bonds, notes, or bills. Now, these 2 options can be combined if the situation warrants. Now, because annuities are the more flexible and prevalent in the funding of structured settlements, we will focus on the annuities as we discuss structured settlement options. As mentioned, an annuity is a contract issued by the life insurance company. They agree to make future periodic payments in exchange for a premium that's paid up front. The annuity contract must have an owner, and the owner cannot be the plaintiff or their representatives, as this would constitute a constructive receipt issue and make the otherwise tax-free payments taxable. Similarly, neither the defendant nor their insurance carrier wants to be the owners of the annuity, since the obligation of the future payments would remain on their balance sheets as a liability. Since neither the defendant nor the plaintiff can serve as the owners of the annuity, the issuing life insurance companies take ownership of the annuities through a separate corporate entity that is created explicitly for this purpose. These entities take ownership of the annuity, and they guarantee the future payments through a process called an assignment of liability agreement. So we have the 7 things that we need to take a look at as to the viability of the option at hand. There is no federal agency in charge of reviewing insurance companies' financial viability. However, their investments are reviewed by the insurance commissioners of the state in which they are domiciled. Additionally, there are rating services such as AM Best that will look at the assets and they will give a rating for a particular life insurance company. That said, there is no entity such as the FDIC which guarantees the funds held by these insurance companies. This was witnessed in 1991 when First Executive Corporation filed for bankruptcy. It was ultimately other insurance companies that took over the payment of the obligations for the annuity recipients at the urging of several state insurance commissioners. So there is some risk with an annuity in the form of potential failure of the insurance carrier responsible for the policy. In cases where an amount of $500,000 or more is being considered for an annuity, My recommendation would to be able to split fund it between 2 or more life insurance companies. The annuity payments are set at the time the policy is purchased. The recipients of those annuity payments cannot take advantage of interest rate increases because it's already fixed and determinable at that time. Further, the plaintiff cannot modify the annuity payment schedule without incurring significant losses or a potential tax penalty. As far as administrative fees, there are no ongoing fees for structured settlement annuities. So the only fees incurred would be the initial annuity placement commission, and that's included in the premium payment, which is paid up front. Level of participation, level of transparency. The plaintiff and their parents really don't have any direct oversight as far as the annuity funds are concerned. And this is handled again by the insurance commissioners and the rating agencies. Communication between the plaintiff, their family, and the annuity company is minimal. Typically, the only contact would be in the event that there is a change of address, banking information, that sort of thing that needs to be presented to the annuity company so the payments go to the proper place. Unless placed in a special needs trust, annuity payments, which are in fact tax-free, would be counted as resources of the recipient by the agencies such as SSI, Supplemental Security Income, and Medi-Cal. And this would potentially disqualify them receiving certain benefits issued by these agencies. Okay, so now let's take a look at a special needs trust. A special needs trust is a flexible instrument. It allows a person with special needs to maintain their eligibility for means-tested government benefit programs, such as Supplemental Security Income and Medi-Cal. And this is despite having financial assets that would otherwise disqualify them from these programs. Assets from an S&T provide supplemental support for beneficiaries beyond that which the government can provide. This helps to improve their quality of life. You see to the left various expenses that are typical in a special needs situation. However, I would strongly recommend that the family should understand that these are just a few of the items and services that can be paid for by a special needs trust. The family should consult with the trustee and their advisors as they become aware of other items or services that would be beneficial to their child. Beneficiaries and their families do have some level of oversight when it comes to the S&Ts, and that's particularly in terms of how the trust funds should be spent and who should serve as the trustee. Now, for parents or caretakers, the sense of control can offer some peace of mind, knowing that their loved one will be cared for by the trust even after they are no longer able to care for them themselves. Now, there are two main types of special needs trust, a first party and a third party. A first party trust is funded with assets belonging to the beneficiary, and this would include the funds that the beneficiary would receive from a personal injury settlement. A third party special needs trust is typically funded with someone else's assets, such as a parent or a grandparent, and this is typically made part of an estate plan. It is critical to work with an attorney that has experience setting up special needs trust. The laws and regulations for S&Ts can vary from one jurisdiction to another. They can be complex, and they are frequently updated. Proper setup is crucial. Vague language in the trust document can lead to confusion and issues down the road, especially in the eyes of the court. It is also important for the attorney to advise their client that in the case of all special needs trust, there is a payback provision back to Medi-Cal. Once the trust is terminated or the beneficiary passes, Medi-Cal places a lien on all of the assets remaining in the trust. This may result in some or all of the remaining assets being seized by the state. Now, if a home is owned in that trust, typically the state will not seize this or consider it. One question that does come up is what happens if the lien exceeds the amount of money that's in the trust at the time the child dies? And the answer is Medi-Cal is only entitled to the amount in the trust and cannot look to the parents for additional payment. We'll go through the key questions of the S&Ts as to security. By law, trust funds are held separately from all other bank assets. If a bank were to become insolvent, funds held in the trust would not be available to that bank's creditors. This happened in 2008 and involved PFF Bank and Trust. It was seized, and all of their special needs trusts were simply transferred to another solvent trustee without disruption. Now, trustees always use low-risk, diversified investment strategies for S&Ts, and all investments are reviewed by the court every 2 years, and this provides an extra layer of oversight. There is also another layer of oversight. Corporate trustees have internal auditors that review this, and the government has external auditors that review the internal auditors' work. Unlike structured settlements, funds held in special needs trusts can be used and accessed at any time. The process for this varies from trust to trust, and in some cases, the trustee may distribute the funds at their discretion, while in other cases, the trustee is simply directed by the independent advisor working with the beneficiary and their family. Again, all of these distributions are reviewed by the court every 2 years. Now, corporate trustees typically will charge an administrative fee of somewhere between 1.5 and 1.75 of the fair market value of the S&T. This is an annual charge. Their attorney will also charge a separate fee to file the biannual accountings. In the instance of private fiduciaries who are assigned the task of being trustee, they charge an hourly fee, which is on top of a surety bond that they have to post, and the investment management fee that they have to pay for the management of the funds under control. Typically, the court will have continued oversight over the S&T with an accounting after the first year, and then biannual accountings after that. Again, we have both internal and external auditors reviewing trust investments. The trustee should also provide the beneficiary and their representatives with regular financial statements for the trust, and these are presented typically monthly or quarterly or annually. The S&Ts can be very high touch or very low touch, and this depends on the beneficiary and their needs. In some cases, the beneficiary needs may call for daily contact with the trustee or their advisory firm. And in other cases, such as when a beneficiary is living in a facility, the trustee may only have limited contact with the beneficiary and the families. In most cases, those with special needs trust are eligible for at least some form of public benefits. Their S&T acts as a safe harbor for their assets, allowing them to maintain their government benefits despite assets limits imposed by some programs. Now we can do a side-by-side very quickly here. In the case of a structured settlement, they issue tax-free annuity payments. In the case of the special needs trust, interest earned may be taxable. In the case of the interest rate, it's permanently set. Whereas in a special needs trust, the trustee can take advantage of rate increases. The structured settlements have scheduled payments that cannot be altered. In the trust of the special needs trust, there's access at any time. With a structured settlement, there are no ongoing fees. In a special needs trust, there are trustee fees on an annual basis, as well as attorney fees during the accountings. The oversight in the case of the special needs trust is by the insurance commissioner's office and the rating agencies. With the special needs, the oversight of the court is involved, as well as internal and external auditors. In structured settlement annuities, there's very limited contact with the family. In the case of the special needs trust, there's typically very high contact. A structured settlement may disqualify the individual from benefits unless it is placed in a special needs trust. And a special needs trust does not affect the public benefits.
Thank you very much, Dan. I see we've lost our share screen. I hope we're working on that from a technical side. At this time, I would like to introduce Mr. Randolph Sharon, the attorney at law, who is going to tell us about the settlement trust subject.
Thank you, Your Honor. So let me remind you, a settlement trust, or what is referred to as a probate code section 3611G trust, is a trust that is established by the court for a minor, again, someone who's under the age of 18, following the settlement of a litigation. The settlement trust is under the supervision of the court, including the requirement of an accounting after the first year and every 2 years thereafter. For a settlement trust, unlike a special needs trust, the plaintiff will not be eligible for certain benefits, including Medi-Cal and SSI. And so let me repeat that. For a settlement trust, unlike a special needs trust, your plaintiff will not be eligible for certain benefits, including Medi-Cal and SSI. Now, in a settlement trust or a court-supervised special needs trust, the assets can only be invested as prescribed in Probate Code Section 2574. Namely, the assets can generally only be invested in bank accounts, publicly traded stocks, and in certain bonds. If the trustee were to invest in a manner not called for in Probate Code Section 2574, the trustee can be liable if the assets go down in value. Accordingly, it is very important to pick a trustee that knows what they're doing. Let's talk now about the terms of a settlement trust. The basic terms of the settlement trust are, number one, the trust is revocable by your minor plaintiff once he or she reaches the age of 18, assuming that he or she is competent to do so. And so again, what that means is that once your plaintiff turns 18, assuming he or she is competent to do so, he or she can simply terminate the trust and the assets will be distributed outright to your plaintiff. The second requirement for a settlement trust is that the trust can be used only for the plaintiff and only as needed. Now, please remember that parents have an obligation to support their children. Accordingly, the settlement trust assets should only be used only if the parents are unable to provide such support. And again, we talked about this earlier, but on a settlement trust, it's exclusively for minors. You may recall from earlier in this program that it was noted in a special needs trust, there must be a provision that provides that upon the death of your plaintiff, Medi-Cal has priority over all other claims, and that Medi-Cal is entitled to reimbursement of the full amount of its claim. Unlike a special needs trust, a settlement trust does not need to have a provision that Medi-Cal is entitled to reimbursement upon the death of your plaintiff. Now, I want to talk briefly about an OBRA 93 trust. Now, if we were to have had this seminar a few years ago, in my opinion, we would have never had any discussion about an OBRA 93 trust. But beginning in January of this year, the laws have been changed regarding eligibility for Medi-Cal. In an OBRA 93 trust, the assets are held for your plaintiff, and the plaintiff will be eligible for Medi-Cal, but will not be eligible for other benefits, including SSI and Section 8 housing. So let me repeat, in an OBRA 93 trust, your plaintiff will be eligible for Medi-Cal, but will not be eligible for certain other benefits, including SSI and Section 8 housing. Now, one of the big differences between an over 93 trust and a special needs trust is that we do not need to reimburse Medi-Cal in an over 93 trust, but we do need to reimburse Medi-Cal in a special needs trust. So the bottom line is this: if you want to preserve all governmental benefits, a special needs trust is the way to go. So who should serve as trustee of a special needs trust? In my opinion, the selection of a trustee of a special needs trust is an extremely important issue, perhaps one of the most important issues. And there are a number of choices. You can pick a family member or any other individual. You could pick up what they call a private professional fiduciary, who is someone who's licensed by the state, or you can pick a bank. Now, as we discussed earlier, in my opinion, it is extremely important to pick a trustee who knows what they're doing in administering a special needs trust. Now, typically, family members will have great expertise when dealing with the disabled plaintiff, but they do not have special expertise in administering a special needs trust. And again, the rules for administering a special needs trust are very complex, and you can get into a lot of problems if you don't know what you're doing. Let's talk now about corporate trustees. Depending on the situation, a bank can be a very good choice in serving as trustee. Not all banks serve as trustee of a special needs trust, but all banks charge a fee based on a percentage of the assets of the trust. The amount charged by the banks can vary depending on the bank, but are typically very similar, and is an annual fee of approximately 1.5% of the fair market value of the assets of the trust each year. Let's talk now about an individual trustee, a private professional fiduciary serving as the trustee. A private professional fiduciary who is someone who is licensed by the state to serve as a fiduciary for special needs trusts, guardianships, conservatorships, and they typically charge on an hourly basis. So which one is better, a bank or an individual serving as trustee? Well, the answer depends on the circumstances. Because banks charge on a percentage basis, most, if not all, banks require a minimum amount before they're willing to take on that responsibility. And that minimum amount can vary from bank to bank, but is typically about $1 million. So if the amount going into the special needs trust or settlement trust is small, the option of a bank may not be available. If an individual is serving as trustee of a court-supervised special needs trust or settlement trust, the court will require a bond. And what that means is that if the trustee does something improper, for instance, steals the assets or distributes the monies improperly or invests the monies improperly, and the trustee is not able to put the money back into the trust, the bond company will put the money back into the trust. So if you have a family member that insists that they want to serve as trustee of a special needs trust or settlement trust, the first thing that I would do is to see if that family member is bondable. I would have them fill out a bond application and we'll send it off to the bond company. Because if it should turn out that that family member is not bondable, then it is simply not an option for that family member to serve as trustee. Now, the cost of that bond, which is paid for by the trust, is about 0.5% per year. Now, in addition to that bond expense, whenever we have an individual serving as trustee, that individual will typically have the money invested at a bank or an investment firm, and that bank or investment firm will charge an investment fee of about 1% per year. Accordingly, if an individual is serving as trustee, the bond expense, which again is about 0.5%, plus the investment fee, which is about 1%. So the total bond expense plus the investment fee is about 1.5% per year when you have an individual. Now, remember, when a bank is serving as trustee, we do not have a bond expense. I think the thinking is that the court understands that if the bank does something wrong, the bank has sufficient assets to be able to put that money back. And so the court will not require a bond when a bank is serving as trustee, and the bank typically does not charge a separate investment fee. And so therefore, if a bank is serving as trustee of a special needs trust or a settlement trust, the administrative expense is approximately the same as the administrative expense when we have an individual serving, namely the bond expense plus the investment fee, before we even take into account the amount that's going to be charged by that individual trustee. Accordingly, for those of you who may think that banks charge a lot more than individuals, I don't agree. I think you need to assess the situation and determine what is best in that situation. Let's now talk about ongoing maintenance of the beneficiary. And I think one of the first questions that you must ask when you're setting up a special needs trust is, how do I get the special needs trust established? And the answer to that question will depend in large part on the type of plaintiff that you have. So for example, if your plaintiff is a competent adult, again, someone who's over the age of 18 and is competent, your settlement and the special needs trust does not need to be approved by the court. Again, let me repeat that. If your plaintiff is a competent adult, the special needs trust does not need to be approved by the court. Instead, your competent adult plaintiff can establish his or her own special needs trust without the court's involvement. On the other hand, if your plaintiff is a minor, again, someone who's under the age of 18, or an incompetent adult, the court must establish the special needs trust as well as approving the settlement. Now, setting up the best option for your plaintiff, including deciding whether to put the money in a special needs trust, settlement trust, or other option, and the selection of the trustee, the person who's in charge of these assets, is crucial for your ongoing maintenance of your plaintiff. Let's talk now briefly about other options for trust funds. And certainly another option in settling a catastrophic injury case is to simply spend the money, such as the purchase of a home or vehicle for your plaintiff, as opposed to going through the cost of creating and administering a special needs trust. So which one is better, a special needs trust or a settlement trust? Or other options, for instance, spending the money? Well, perhaps needless to say, there's no one best option in all circumstances. But let me close by saying this. My best advice to you is to take into account all of the facts that are available to you, consider and know all of your options, discuss the matter with your client, and make an informed decision. Thank you.
Okay. Let's see, let's get to, all right. Now that we've had a chance to hear from everyone, let's take a look at something that we could actually put down and see how this all works. So this is the personal injury settlement case study. So in this case, we have a 4-year-old child. the child was left permanently injured and will require full-time care for the remainder of their life. The life expectancy is estimated at 76.8 years. The life care plan developed by the RN life care planner is at 14.4 million. And you can see here from the pie chart, 81% of that has to do with day-to-day care costs. Now, the economist is important in this whole thing too, because they've come up with a present cash value to come up with that $14 million. However, as we know, there are limitations as to how much money the defendant is willing or can possibly pay. That's where the negotiation comes in. So what we wanted to provide to you, and what I wanted to be able to set forth for your consideration, are three very simple little examples. And this is coming from my 40 years of experience doing these types of settlements. So in outcome one, we have a net amount to the beneficiary of $1 million. Outcome two, we have more money. We've got $3 million. And outcome four, it works out to $5 million net. So we have limitations here because we only have the $1 million net. My recommendation would be to put it basically in a special needs trust. The family has access and they can continue with the public benefits. Unfortunately, with a net award this size, it's going to be difficult to purchase a home, for example, for the family. That's going to be a tough one. It might be difficult, it might be possible to purchase a specially modified van. So let's go on to the next one here. Scenario two, we have more money. So what I would suggest in this particular case, put $2.5 million into a court-supervised special needs trust. They maintain their public benefits. However, let's diversify a little bit. Put $500,000 into a deferred lifetime monthly annuity. These benefits won't commence until the plaintiff hits age 18. The thought behind having the annuity contract paid into the special needs trust is that the annuitant will never outlive the benefit. That money is going to keep on going until they pass. In the final scenario, we have more money. We have $4 million into a court-supervised special needs trust. We place $500,000 into a deferred lifetime annuity, benefits beginning at age 18. However, we have another $500,000. And we can place that into an immediate lifetime annuity plan. And those payments will start immediately to help defray the ongoing care costs of the individual. Now, I've gone through this all very, very quickly. Again, I wanted to be at least able to give you some idea as to how to look at this once you get to the point that you have the final funds. Thank you again for your participation.
Thank you very much, Stan. We've listed some additional resources here for your edification to the audience. And in final analysis, we have the key takeaways here for you in this last slide with the three areas. Involving the key players early and leverage their expertise to ensure the client's future needs that are met. Weigh your options based on award judgment amount and client needs, and keep good communication with your clients and their families. Do we have time for questions at this time, Cameron? And would you let us know where we are on that?
We have about 5 minutes left if you would like to take some questions. I see that they are posted in the Q&A. Judge Person, would you like to sift through some of the more relevant ones?
I'm going to leave that to Cameron. You have access to that, Cameron?
I do. I'm looking through them now. So I'll start with this one here. Do you find that plaintiffs are using life care plans in cases where the injury is not catastrophic? For example, a minor accident with a neck surgery by an attorney referred provider that was done on a lien. So if we can unmute all of the presenters, if anyone wants to chime in.
So,
Karen?
oh, Karen?
Well, I was just gonna say if there's only in the future very small number of things needed or not a lot of items, that the medical doctor can usually recommend them, and if it's not ongoing, if it's like a one-time surgery with just a few things with it. But if there's a whole bunch of items, you definitely need a life care planner. Barbara?
I agree.
Okay, I have another question here. What do you do when a patient's condition is in flux but unable to be determined before trial? Good question.
So as a life care planner, I usually like to see that the client is permanent and stationary. That's a workers' comp term, but or reach maximum medical improvement. That doesn't always happen, and oftentimes in the life care plan, future care is, includes surgery. So that's why I consult with the expert physicians, so that we can make a determination that is medically likely and reasonable to occur.
I have another question here. How do you handle potential future treatments? I have a case where a doctor has opined liver transplant will be likely to be necessary in 5 to 10 years.
Again, as a life care planner, as long as the doctor opines that is medically likely and reasonable to occur. So greater than 50% chance that this is going to be needed. And then the economist is going to have to deal with, providing those funds in 5 to 10 years, right, Karen?
Yeah, we would include it, in the life care plan and do a special line item and when the timing is and what the present cash value of that would be. And then it may or may not affect, the earnings, loss of earnings.
And you may want to also consider an annuity payment that would kick in at that particular time. It's a thought. It would be tax-free money. It would come out at 5 years or whatever the situation calls for.
We have another question. Are there any options for a patient who lives beyond their life expectancy?
Lives beyond their life expectancy? Well, an annuity is just exactly that. A life annuity will pay for the duration of the individual, no matter how long they live. What often we see in the case of children, however, is we will have a guarantee period that will be added to that lifetime annuity. It can be 5, 10, or 15 years. What that means is that the annuity must pay out at least a minimum amount. And if the child dies in year 1 or year 2, then the heirs at law, being the parents, would receive the remaining annuity payments, whatever they might be. If they could be 3 years or 17 years, depending on the guarantee period added to the life annuity.
Do we have time for any more questions, Katie?
We just had a couple questions left. I think we could.
Okay, we only have 4 questions left, so I think we can try to power through those, and if anyone needs to drop off. Another question, are the structured settlement special needs or settlement trust necessary when the plaintiff has long-term permanent injuries but is not cognitively impaired? And do you find plaintiffs object to this type of settlement versus a lump sum payment?
It's really a decision that the attorney and the plaintiff need to make. The plaintiff, let's say he's 35 years old, he's cognitively fine, he's just physically disabled. What he would probably want to consider is some type of other trust fund, possibly that he has access. If he's not concerned with receiving public benefits, if he's not concerned with public benefits. And again, this depends upon the size of the award. If it's a smallish award, he may just want to take that in cash and worry about it later. But if it's a significant award, I think there's some consideration that he or she might want to be able to say, I'd like the idea of having some tax-free money, either coming out of that annuity contract or having greater access to a trust fund.
Regarding reporting a lawsuit to Medicare, do you know when a plaintiff is required to report to CMS? During litigation, before a settlement?
Well, I don't, so Mr. Sharon might be able to address that, but if I know that an individual is either currently receiving Medicare benefits or will shortly receive Medicare benefits, I usually discuss with the attorney contacting a MSA specialist, so somebody that will create a Medicare set-aside trust. That way you don't have to worry about that issue. And there are some life care planners that do MSAs as well.
Yes, I agree with that, Barbara. And I also think that when you're dealing with anybody, including a minor who has end-stage renal disease, that's another situation where there may be a need for a Medicare set-aside account set up. Again, I would work with an expert. There's a number of firms out there that handle that to determine whether or not a Medicare set-aside account should be set up. I would do that prior to the time that you've settled a matter.
If I may also, if the person has end-stage renal disease, that's really important for the life care plan, because the life care plan provides cost of care. And if there is end-stage renal disease, then we'll know that Medicare will provide some services. They often will provide, kidney transplants, ongoing dialysis. That has to be noted in the life care plan.
We have one final question. I believe this one is for Mr. Sharon. What if other family members are beneficiaries of another trust for Section 8 housing?
Well, I think that we're going to view that separately and apart from the settlement of this matter. I don't think that this settlement is going to affect them.
All right, that brings us to the end of our questions from the audience. Thank you, everybody who submitted questions, and thank you to our speakers for sticking around for a few extra minutes to answer all of those.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.